The opinions on this program are those of the program host and guest and not necessarily those of WPSL. WPSL does not endorse products that may be mentioned. Any reproduction or retransmission of this broadcast is strictly prohibited without written consent of WPSL. Legal questions? Ask a lawyer. Give us a call at 340-1590, 340-1590 here at the studios of WPSL. And Ask a Lawyer with your host, attorney Stuart M. Address.
Good morning, Treasure Coast. I'm Stuart Address, and we're here for another edition of Ask a Lawyer. And before we start, Cliff, during the Swap Shop show, he says that is the fastest hour in radio. I have a bone to pick. I don't know. I think last week's Ask a Lawyer was pretty darn fast. So we may need to compare one day. Mm-hmm. And, one other thing.
We do say that about most shows because it is amazing, though, how quickly the hour goes.
Yes, it is very amazing. I have found, having only done this now for about 3 months, how quickly the hour goes, how much you overestimate what you're going to be able to say. Mm-hmm. And last week sort of reminded me, and I think I even put it on my firm Facebook page, it reminded me of an appellate argument. Because whenever you go into an appellate argument, the judges just throw questions at you. It's like the Supreme Court. So you have your presentation ready. You may get into, may it please the court. The next thing you know, questions are thrown at you for the entire period allotted for argument. And then they say, the red light comes on, and they say, you're done. And you haven't had a chance to make an argument. You just answer judges' questions. Mm-hmm. Well, that was last week's show, and I enjoyed it very much. So if any of you out there have any questions, think you may have a case, are wondering about an area of the law, give us a call. Let's talk about it. Sometimes it's a little bit more fun than things I might prepare, especially if I have to prepare things for 100 shows. Anyway. One other thing I heard on Cliff's show that proves I do actually listen. So I don't just have a show. I listen to WPSL. One of his advertisers, obviously, the St. Lucie Mets. I'll tell you one thing I like about the St. Lucie Mets. I've always liked, ever since I moved here, about single A ball. These players hustle. They are looking at the next ring, which is double A ball, and there is no jogging to first base. They hustle, and they play baseball the way I remember playing baseball, the way I've always told my son to play baseball. I remember one spring training when the Mets had Ricky Henderson, and he just jogged to first base on a ground ball, and I was really close to the field. I have a loud voice, and I yelled something to him. I don't remember exactly what it was, but cleaning it up a little bit, it was probably something of, hustle you know what. And he turned and he glared at me. So at least I knew I got to him. But that's the problem sometimes when you're making millions of dollars. You slow it down a little bit.
Yeah. Even you can say that about football as well, because if you watch college, they're playing the game.
Well, that's what they say. Sometimes
in the NFL, they don't want to get hurt.
In all the sports, sometimes owners are concerned about giving these long-term contracts, because with some players you lose incentive. With other players, other personality makeups, it increases your incentive because you feel an obligation to live up to the contract.
Okay.
And it's like anything else. You have to understand who you're dealing with, which is why the best coaches in all sports and college, high school, whatever level, they're the ones that don't treat everybody alike. They get to learn which player needs a kick in the butt and which player needs a pep talk, because everybody responds differently. And when you learn how people respond, you're better able to tailor your message. Anyway, so that's my little plug for the St. Lucie Mets and why I like the St. Lucie Mets so much. And I enjoy those games, especially when it's not 10,000 people there. I can get really close, really cheap, and enjoy the game, especially when I've taken my son in past years. And so we now have another season coming, and hopefully I'll get there real soon. All right, a final word or two about insurance companies who like to practice medicine. You may have remembered a couple weeks ago that we were talking about this, and one of the issues we were talking about was actually a personal issue where I didn't describe the real facts, and I won't. But there was a denial of coverage that related to somebody in my family, and I thought it was wrong. And I made noises. The noises didn't work. I then wrote a nasty letter that cited sections of the ERISA statute. And the next thing I know, the denial is overturned. Okay, so something happened from the morning I wrote that letter to 2 o'clock in the afternoon when all of a sudden I got a call that the denial had been overturned. Funny thing, though, I just got a copy of all the records, all the documents that I had asked for, 150 pages.
Mm-hmm.
And they document everything. Every email I sent them was there verbatim. My telephone calls they must tape them because they were better. They were better than summarized.
They were transcribed.
Right? My threats about "don't mess with me, I'm a lawyer." It was right there. It was there. When they approved care, all the reasons were there. When they denied,
did you look at it and go, "Did I really say that?"
A couple times, yes. A couple times. And then I see the first denial, and it's very well documented. And then I see an appeal and a denial. It's very well documented. And then I see an expedited appeal, and it's documented. And then all of a sudden I see one page overturned. Nothing to explain why it was overturned. Nothing that explained how it even came to their attention to overturn it. My letter wasn't there in all these documents that I had requested to produce. Mm-hmm. It was like Watergate. There was an 18-and-a-half-minute gap. Now, as a lawyer last night, I read these 150 pages because I got them in the mail and I was curious. And I immediately noticed that little hole in documentation. And I said to a couple people that if this was for a client of mine, my next step would have been writing a letter to the attorney saying, there's a hole here, give me those documents. Where's the rest of it? And then it would have been a motion to compel, and then order to show cause why they shouldn't be held in contempt. But since my situation is resolved and it's for me, I don't need any more aggravation. I'm going to let them get away with it because I got what I wanted. But I guess the takeaway for the people who are listening and those who you may want to talk to is, and I don't know if I mentioned this 2 weeks ago, but in case I didn't, I am going to put a redacted version of that letter that I sent to the insurance company on the law firm's Facebook page. So you just go look for, law offices of Stewart M. address. It's a public Facebook page, obviously. And hey, I hope you actually like it. And those of you who are on Facebook know exactly what I mean by like it. I don't just mean enjoy it. I mean like it. But I'm going to put that up there so that, if anybody has an issue, maybe even before you ask a lawyer or go to a lawyer, you at least have this template of what the ERISA statute says you're entitled to, because at least in my situation and a few others I have heard about, that type of a letter has quickly engendered a reversal of denials of care, and it certainly did so in my case. I
would be very curious to find out their original rejection of filling that order from the doctor.
Well, I got all that.
Did they say, because what happened with me recently is they said it's formulary.
And that's for a prescription, right?
Yes.
Yes. Okay.
Yes.
And I get that too. And I got.
You go to fill it and you go get. No, they rejected. What do you mean they rejected?
It's even worse than that.
It seems like they're buying time and moving you down the road so that they're saving themselves some money.
Well, of course that's true, but it's even worse than that. I've had Blue Cross Blue Shield for many years now. And, of course, every year is a new policy. Mm-hmm. And every so often, because of, premium increases and all, I have to change which plan I have on Blue Cross Blue Shield. So you go through this little checklist they have there, put all your medicines in there, make sure they're covered under the plan you're going to. And you put your doctors in there and, make sure they're still in network.
Right, and they're supposed to help you find the perfect fit.
Right. So I get this new plan as of January 1st of this year. And I submit one of my prescriptions for the first time this year, and I get to the pharmacy, and they say it's $1,800.
Yeah.
I said, what? That can't be right.
Yeah.
Last year I paid $60. So, of course, I have to go home. I have to call the insurance company, and I'm told, well, last year this particular medication was a level 4 drug.
Yeah.
Now it's a level 6 drug. And that means you have to pay 50% of our cost and blah, blah, blah. And sure enough, I go and I look at their formulary list, which is hundreds and hundreds of pages long, and I find the change from level 4 to level 6. They didn't tell me that when I checked to see if the prescription was still covered. Now, again, I think I did mention this once on one of our shows very recently. Anytime this happens to you, immediately at the very least, go to the manufacturer's website, because very often they have these coupons that are good for a year that dramatically reduce the cost of your prescriptions for that particular medication. And I'm not talking about these cards that say, well, we'll up to 60% off on all your prescriptions. I mean, some of them are helpful too.
Now, this is specific for
I'm
what you're
talking
taking.
about, for example, I have diabetes, so I have some diabetic neuropathy, and I take Lyrica, okay? And that was one of the $60 drugs that now became that was like $900 or something. And wow, I mean, I need that particular medication.
Right.
I'm not going to pay $900. What am I going to do? And that was $900 for 3 months. And so I went.
Even so.
Yeah, right.
Yeah.
So I went to the website and I pulled this lovely card down from the manufacturer, and I brought it to Walgreens, and the month's cost, instead of now being $300 and change, was $78. A little bit more than the $60 I was used to paying. Perfect. I'm satisfied with that. So if you find whether your medications change or your insurance changes, or you just have medications that are really, really expensive. I mean, maybe you're on Medicare, maybe you have private insurance, doesn't really matter. I always hear, I'm not talking about people that call my office, I just generally hear people complaining, boy, the cost of prescription drugs. Folks, first thing you do, helpful hint, go to the manufacturer's website and see if that drug has a coupon. They do this quite frequently because, let's be honest, if your physician has prescribed that medication, and if there are other choices, unlike with Lyrica, the manufacturer wants to hook you on their drug. They want you to take their drug. They want you to like their drug. They want you to keep wanting their drug. And so they'll give you a year, and very often then you'll be able to get another one.
Yeah, but by next year, your plan's going to change again anyway, right?
Right, but very often, very often you'll find the coupon. You get another coupon now for the next year.
Yeah.
And, the manufacturer's not really losing money. It's the insurance company.
If there's people out there paying the $300, or insurance is paying the $300.
Just a little friendly hint. It doesn't even really involve calling a lawyer, but it's just something I have learned. And, when I've heard family members or friends say, oh, my goodness, go to the manufacturer's website. 50-50, 60-40 chance you're going to find a coupon, especially if it's a popular medication. Anyway, so let's move on to trying to conclude our discussion about sexual harassment.
Okay.
And who knows, that discussion may come back 3 weeks from now, 6 weeks from now, a year from now, because it's always going on, unfortunately. You listen to the news every single night, more and more and more.
Topic du jour.
There are two topics that are always in the news right now. What did Trump say? And who is alleging sexual harassment against whom? I'm not sure which one is more entertaining. But we had talked about complaining about sexual harassment, whether it's statements and comments that are made to you, comments that are made in your presence, touching, even if it's just brushing up behind you or touching your shoulder, if that is offensive to you. And then the more serious things really that get particularly disgusting. And I unfortunately can say in over 30 years, I think I've seen it all, but I keep getting surprised. So you've got to complain. That's just not my advice. The Supreme Court of the United States has said you've got to complain. If you don't complain, if you don't follow the procedures your company has established, if you don't follow the procedures at least approximately that are in the employee handbook, if there are procedures, and a lot of companies have them now, When you try to file a claim for sexual harassment, you will soon find that the employer has a defense. And the defense is your failure to complain. Why? Because your failure to complain takes away from the employer the opportunity to conduct an investigation promptly.
Well, really, they don't know they have a problem unless you let them know.
Most of the time.
Unless they are the problem.
Well, sometimes that's true too. And the other part of the investigation is the employer's obligation is if they determine that there's reason to believe that sexual harassment or even other forms of discrimination, which we'll get to, has occurred, they now have a duty to take prompt remedial action. So if you don't complain, you're going to find that you either get dismissed out, summary judgment out, or lose at trial on that issue. Now, there is, as is everything in the law, an exception. I like the exception when I'm able to use it. I don't like the idea of having to fall back on the exception. I think it's dangerous. The exception is where the employer has reason already to know of what is occurring, or there has been a pattern of that type of conduct in the company, and the employer already has not done anything in the past. Then you may be able to fall within an exception where your failure to report or complain because you were concerned you're going to lose your job or there would be consequences might not be fatal to your claim because the employer already knew this stuff was going on and should have acted. That's the exception. You can imagine if you're trying to fit yourself into that exception when it comes to a court, it's going to be your burden to prove that the company really knew what was going on. I would rather have my clients have put in a complaint in writing, email, fax, anything that's provable. Get lots of people who call me and say, well, I complained to my boss who was doing it. That's great. You need to do that. And then I called HR. Did you follow up with HR in writing? Did you get anything from HR in writing? No. And I sigh. And it doesn't mean you don't have a case. It just means it's going to be a little bit more difficult because what if this is the kind of company that says, they never called us.
Mm-hmm.
Now, a lot of big companies, it's wonderful. They have corporate HR numbers. You can call anonymously, and they give you a code number to prove you called. I love that. I think those are excellent HR procedures.
So at some point you are no longer anonymous because you're the code, and if you have a case,
well, once you
by
sue,
then you don't care if you're
right,
anonymous.
by then you don't care.
Yeah.
But the worst thing that most people, and it's usually women, but men are sexually harassed as well. We discussed that. The thing that they're usually most concerned about is, I don't want to lose my job, number one. I don't want to be retaliated against, number two. I don't want to be made to feel further uncomfortable because I've complained. And those are all very legitimate, real-world, real-life concerns. Unfortunately, the Supreme Court has said, we don't care. Okay, we're balancing employer-employee rights, and if you don't complain, then the employer is going to get off scot-free. So I would prefer, and I counsel people who call me where they're in this situation, some of them say, I want to quit tomorrow. And I say, don't do it. Do an email to HR, complain about it, stay there a week, and then if nothing's done, send a resignation email saying you just cannot continue to work in this environment, and it's viewed as a constructive termination, not really a resignation. I'd even argue that on unemployment. And sometimes I'll get, clients will say, okay, I'm going to do that. And I say, well, call me, let me know what happens. Maybe it'll work out well for you. You won't need me. If it doesn't, give me a call. But then I'll have some people that say to me on the phone, I don't want to do that and go back to work. All right, that makes life a little bit tougher. So what I'll say to them is, do you have any PTO time coming? Do you have any vacation time? Do you have any sick days? If so, let's try to set up where you can take 3 or 4 days off. And then when you leave work that day before your 3 or 4 days off, you send in your email. You're now not there. And when your 3 or 4 days is up, if they haven't contacted you, if they haven't taken appropriate steps, then I think you're probably safe in resigning and having a lawyer like me argue it's a constructive termination.
And I would think that you would know it's resolved. You come back from those personal days or vacation, and your supervisor should tell you, we've addressed the problem. Here's what we're expecting to happen. If you have any further problems, let us know. And then you should know you're kind of okay.
And in the best of all worlds, that is exactly what happens. And truthfully, it happens quite often. You know, not every employer is the evil monster that lawyers like me might like to make them out to be. There are plenty of employers out there who do the right thing, who want to do the right thing, and who are told if there are problems, will do everything they can to do the right thing. They're great. Mm-hmm. It's the Neanderthals that I deal with, the ones who like to stick their head in the sand, who peeve me off. I'm using a politer word since I don't want the FCC to come after me.
In a way, why wouldn't they address the problem? I mean, because then everything is more harmonious in the office.
Because some of them just don't want to deal with it. Some of them don't have good HR departments. Some of them would rather take the harasser's word against the victim's word.
Are they a better employee, a more valued employee?
Well, sometimes they are. Sometimes they make the company buco bucks, mm-hmm. and you don't want to let go of them. And so you'd rather just...
Boy, that person feels like a liability to me.
They are. I have a case right now where it is my goal in life that person, after several incidences and complaints, that the company ended up making settlements, and now we have another one.
Same person.
Same person.
Ooh.
But this time, this person will no longer be working there. One way or the other. Okay, it's my hope, my goal, and it's part of our demand letter. So that's all I can really say.
Mm-hmm.
But yes, there are situations where somebody may make a company a lot of money, and they don't want to lose them. They'd rather lose you, and unfortunately, that's illegal. If you're really being sexually harassed.
If that one, how many women prior to the one that's complaining has already up and left, and you don't know why they left?
Well, who doesn't know why they left?
The employer.
Oh, sometimes the employer does know why they left because they filed claims.
Okay.
That's where you have a real problem as an employer.
And the employer's okay that they just leave, they file a claim, and they leave, and then they just continue doing the same thing.
Sometimes the employer seems to be okay with it. Sometimes the employer seems to be okay with settling a claim and allowing the person to remain in their position. And I'm not just talking about the case I'm dealing with right now. I've had other cases where, the person has remained there, and, I've had a second person call a year later, 2 years later, sometimes with a legitimate case again. Sometimes it turns out they don't really have what I think is a strong case, but it's amazing to me that person is still there, mm-hmm. Allegedly doing these same types of mm-hmm. things. So, complain, folks, and if you're concerned about how to complain and what the consequences are, talk to a lawyer, call us, try to set it up where you have some time off. There are lots of ways we can work within the system, but don't just give up and say, I'm not going to say anything because I'm scared. And I think at this point we are about to go to a break.
We're going to take a news break. We'll be back with more Ask a Lawyer. You're listening to WPSL 1590.
This is WPSL Port St. Lucie, the talk of the Treasure Coast.
case of a driver who received a ticket in Aventura in South Florida. His attorney tried to argue the program isn't valid because a third party reviews all the red light camera photos and then passes them on to the police department to determine if a ticket is warranted. Tickets can set you back $158. Florida Power and Light conducted its annual pre-hurricane season drill, getting ready for an imaginary Category 3 storm threatening the state. Utility officials say they're ready to get the lights back on ASAP in case of any outages. FPL President and CEO Eric Szilagyi recommends that customers be ready with emergency supplies.
Make sure you've gathered key supplies, batteries, flashlights, fresh water. Make sure that your important documents are in some waterproof containers and you know where they are.
Also, know your evacuation route. The hurricane season begins June 1st. Graduation season is in full swing across the Sunshine State. Former Governor Jeb Bush spoke at the University of Central Florida commencement in Orlando Thursday afternoon, a little over 2 weeks after his mother's passing. Bush's speech was short and sweet, just like Barbara Bush would have wanted.
So when I would ask her what I should speak about, she would always say, Jeb, speak about 10 minutes and sit down and shut up.
Jeb Bush encouraged the graduates to be of service to others and be involved in causes far bigger than themselves. He was presented an honorary doctorate in public service from UCF. Lots of Floridians are preparing to celebrate Cinco de Mayo tomorrow. AAA says the Tow to Go program has been activated for anyone doing too much celebrating with no safe way to get home. With news on the Florida News Network, I'm Alan Spector.
I'm gonna clean the tub and shower. It's a big job, so nobody interrupt me.
Okay.
After my shower or bath, I'll spray Wet and Forget Shower on and rinse it clean tomorrow. Easy. Now I have time for a nice long bubble bath.
Hey, hon, you need a hand?
Could you make dinner?
Sure.
Make cleaning easier. Pick up Wet and Forget Shower today at participating Ace, Do It Best, True Value, or visit wetandforget.com for a store near you.
Imagine a great day on the water in Florida. You're at the wheel of your boat, safely towing family and friends on a tube. Everyone is having fun. You can make it a reality by remembering the person being towed has no control of where the boat is going. As the boat operator, you are 100% in control of the direction of the tube. Never swing a person near docks, trees, boats, or any other objects. The result could be tragic. Safe boating is no accident. Visit myfwc.com.
In the Panhandle, the former CEO of Calhoun Liberty Hospital in Bluntstown is facing charges for allegedly embezzling more than $1 million from his own hospital. Philip Hill Jr. was indicted this week for allegedly setting up a fake medical supply company and then billing the hospital for supplies he would buy online at a much lower price. A whole lot of praying at the state capitol. More than 100 people showed up at the top floor observation area to take part in the National Day of Prayer. Pam Olson with the Hilltop House of Prayer says America needs it, and so does Florida.
We're a divided state as well, and we've been through so many things with the mass shootings in Parkland and innocent life loss, with the hurricanes, with things that have happened, and the reality is only God can heal hearts, and only God can bring protection.
The National Day of Prayer dates back to a congressional resolution passed in 1952. Alan Spector, FNN News.
Ask a Lawyer continues on WPSL. Phone lines are open 340-1590, 340-1590. Now back to your host, Attorney Stuart M. Address.
And I have breaking news for everybody that is right on topic. We were talking about there are actually employers out there who care and who will try to do the right thing. And less than 30 minutes ago, the Wall Street Journal reported that Nike CEO Mark Parker apologized to employees for permitting a workplace culture where some felt excluded and management didn't take complaints seriously. Multiple executives have left Nike in recent months because of reports of inappropriate behavior and poor workplace conduct. So this is just an illustration, and I understand that as this story has just broke, it is on the national news right now, but don't leave me. At least not for another 20 minutes. And this is, an illustration of where there are employers who it may take several or it may take time to get up to the top, unfortunately, but who don't agree that this is the way things should work.
I'm feeling excluded. I don't understand what that means, though.
What do you mean?
I'm feeling excluded.
I'm feeling excluded. Well,
their employees felt excluded.
Excluded.
Somebody need a hug.
I guess we're going to find out, but excluded. Not part of either promotions or it's an old boys club or, decisions are made in the men's room. There's a whole lot of ways that could be interpreted. And I don't know, what was happening obviously at Nike, but I guess it's going to be coming out in the next couple days as to really what was going on. According to the Wall Street Journal, they had an all-staff meeting recently, and the CEO apologized to the employees and who felt they didn't have anyone to go to with their concerns. And now we're going to see, I guess, how far does that go and what lawsuits may be coming out as a result of that. And with that, we go to Rick on line 2. Hello, Rick. How can I help you?
Hi. I just wanted to answer a question. I was just wondering, if somebody has a judgment against you, can they actually garnish your retirement, like from Social Security and retirement that you're drawing from the state?
No. If they have a judgment against you, there are certain things that are protected from being garnished or levied upon. Among them are, Social Security, things like that. Most retirement benefits are included. Most 401ks, different types of IRAs are also included in those things that can't be garnished. There are, as I mentioned before, always certain exceptions, but they're narrow exceptions. So for the most part, the answer to that is no.
Okay. I guess where would I go to make sure that they couldn't get to your regular retirement, not just the Social Security?
Okay.
I'm sorry. Go ahead.
Is it a curiosity right now as a result of something that might happen, or is somebody attempting to do it?
No, something that might happen, and I was just wondering if they could do it.
You can actually, if you want, you can call my office and get to my paralegal, and I can look at it next week. Just take a look at it and make sure whether, all retirement savings are protected or whether there are certain exceptions. Lawyers hate to always give definitive answers to anything because there's always law that people don't know. But you can feel free to call my office. It's 772-781-8003. Or, obviously, feel free to call any lawyer you're comfortable with, and, they may be able to help you with that. Especially, lawyers that practice, in the area of collections and garnishments, things like that.
Okay, great. Thank you very much.
You're very welcome. Good luck.
All right, thank you.
Bye-bye.
Give us the address, the phone number again to yours.
It's 772-781-8003. Mm-hmm. And not to confuse you, if you want to call me right now, it's 772-340-1590. So give us a call. Now, what is the time frame that you folks have to do something if you believe you've been sexually harassed, or again, other forms of discrimination, which we'll touch upon briefly because the rules are essentially the same. So, other forms of discrimination: age, race, religion, national origin, gender, other than sexual harassment. We're getting to the point where some courts are saying yes, some are no about sexual orientation. So the rules are all the same because it all falls under Title VII of the Civil Rights Act and the Florida Civil Rights Act. You have to make a report, in Florida at least, within 300 days of the last activity that you believe was discrimination. And that means you have to file a charge of discrimination with the EEOC or the Florida Commission on Human Relations to preserve your rights. Those administrative filings are a necessity under the statute. You can't just go sue. Sometimes I feel that's unfortunate.
So I would come to you and you would file those papers?
Yes.
Okay.
Or honestly, you can do it yourself. And
okay.
If you're not sure how, the EEOC will actually send you a questionnaire. You fill out the questionnaire, and they will draft the charge of discrimination and send it to you for review. This is supposed to be an easy process. And to actually file a charge is a relatively easy process. What happens after that, unfortunately, no longer goes the way it was intended. But we'll talk about that in a moment. So you've got to do this in 300 days. Now, you have 300 days in Florida because we have a Florida Commission on Human Relations, and the federal statute says that where the state has a corresponding statute, you get a longer period of time. If you're in other states, Title VII actually says you have 180 days. So Florida, you get an extra 120 days. Sometimes we're lucky. Sometimes Florida gives us nothing. Okay, here you got a little bit extra time.
We need the extra time. We're a little slower down
Now,
here in the South.
What happens when you file that charge of discrimination? Well, what is supposed to happen and what used to happen is the Florida Commission on Human Relations has a work-sharing agreement with the EEOC. And by the way, folks, that's the Equal Employment Opportunity Commission. And they would tell you, well, we're going to let the EEOC investigate, and whatever they do is our decision too. And the EEOC would assign an investigator, send a copy of your complaint to the company and ask for a response, ask for a reply from you, maybe even contact some witnesses, do some investigation, often offer mediation sponsored by the EEOC, and try to work it out or really come to an answer as to whether the EEOC believed there was cause to conclude that discrimination likely occurred or that it didn't occur. That used to happen. It used to happen until the EEOC budget was cut over and over and over again, until the EEOC lost staff over and over and over again, until it became a less important agency. And now, truthfully, what happens is a lot of nothing. Now, that's not to say it happens all the time, even in my cases. Sometimes an investigator is appointed, and then nothing happens. Sometimes an investigator is appointed, and they do send something to the employer, but calling witnesses anymore, trying to really get to the bottom of it, no. Now, if you're 500...
Well, yet they're not going to really do anything, but you still have to file with them.
But yes.
Okay.
Statutory requirement.
Okay.
So if you're 500 people alleging Walmart is not promoting you because you're women, oh, yes, the EEOC is going to do something and have. Because the EEOC has the right to take the case and actually file suit. Usually it issues what's called a right to sue letter, and then you have a private attorney who handles it if they believe that you really have a good case. So if they are so overworked and understaffed that very often they don't do anything when a single person is complaining about any form of discrimination, what are you supposed to do? Sorry, nothing. The statute requires that you file with the EEOC or the FCHR, Florida Commission on Human Relations. You cannot get away from that. You cannot bypass that. You cannot pass go. You don't collect $200. There are very few things that are hard and fast in law. That is one of them. It's in the statute. So if they're doing nothing, how long do you have to wait? Well, the answer is...
Well, how long can you wait? Because
well,
there's probably a limit on that as well, right?
No, there is no limit on that.
So
it could be
so
years.
So if you're patient, you can wait.
You can wait. Now, in the EEOC statute in Title VII, it doesn't say how long. You can complain, and 2 days later say, issue me a right to sue letter. And they'll close their investigation. They'll issue you a right to sue letter that says we were unable to conclude, and you now have 90 days to file a lawsuit. Why wouldn't you do that if most likely they're not going to do anything anyway, so you can just get into court? Is a really good reason. Because you cannot file the state law claim under the Florida Civil Rights Act unless you give the FCHR 180 days to try to resolve the issue. That's in the state statute. So what do I do when I have these situations?
So you have to give them time for them to do nothing for you.
Correct.
Okay.
Hey, I don't make the laws.
No, it makes perfect sense.
Send me to Congress. I don't make the laws.
It makes perfect sense.
So what I do as an attorney is I will wait the 180 days that gets me into the Florida state remedies, and then I will ask the EEOC for the right to sue letter so that when I file the lawsuit, I can have count 1 under Title VII of the Civil Rights Act, federal claim. Count 2 under the Florida Civil Rights Act. Now, why do I want to do that? Because some attorneys don't do it, and I'm not saying they're wrong. Some attorneys file these claims in state court using the Florida Civil Rights Act. They have their reasons, and sometimes some of them are good reasons. Generally, I don't do that. I will file virtually every discrimination claim in federal court. I'll file it under both Title VII and the Florida Civil Rights Act. And the reason is really very simple. While the remedies that you can get are almost identical under the federal and the state statute, they are not identical. And without going into the weeds, there are some important distinctions in what can you get for compensatory damages? How much can you get for pain and suffering? Can you get punitive damages? And so if you have a claim under both counts, under the state and the federal statute, and if you end up going to a jury, the verdict form that is going to be given to the jury isn't going to tell them, well, this is under the state statute and this is under the federal statute. It's going to go through all the remedies, and the jury's going to have to answer the questions and make monetary decisions as to whether anything is appropriate. So I do it because it enhances the prospects of my clients getting a full or a maximum recovery. Might as well get the benefit of both statutes. If we are in 2 years going to get to a trial, most of the times it doesn't happen. More than 90% of all civil cases settle. But if we are going to get to a trial, and if I'm going to have to do a closing argument in front of a jury, I want the jury to have to go back to the jury room with as much opportunity as it has to give my client as much relief as possible. And so I wait the 180 days, and then if I'm going to sue for a client, I file suit usually in federal court and arguing both statutes. So that's a little bit about how long you have to wait. Now, what do I do if somebody calls me before they have filed a charge of discrimination? And a lot of attorneys do it, not all. And again, everybody has their reasons, and I'm not saying the people that don't are wrong. I'm saying this is my way of doing things. I'm going to send the employer a demand letter. I'm going to take all the information I'm able to get from you. I'm going to fashion it into what hopefully is a terrifying letter of what is going on in that company.
Being a defendant in federal court would be terrifying, wouldn't it?
Hopefully.
Yeah.
That's my goal.
Yeah.
You know, and then I'm going to lay out the remedies available under the statutes, and I'm going to ask for an amount of money, which we know is not what you're going to get, and we have ways of why we ask for what we ask for, so that we hopefully get you something that's reasonable. And the goal is to try to engage them in discussions. One of the reasons you do that is because there are a lot of companies, small, medium, and large, that will negotiate with you so that you don't take that next step and file the charge of discrimination, because once you do, it's public.
Do they sometimes ignore you completely?
Oh, sure.
Okay.
I tell, there's a routine when I have somebody in my office and I'm going through, you know, I'm going to send a demand letter. I tell them there are 3 possible responses. Right now, my paralegal Cheryl is laughing hysterically in my office. Because when I say this, her eyes roll back in the conference room. She puts down her pen, and I don't know, maybe she turns on her music or something because she's heard it so many times, she doesn't need to hear it again. The 3 possible responses. 1, you're ignored completely. It is not the typical response. Typically, you do get a response. But sometimes you're just ignored. And if you're ignored, then you and your attorney have to make a decision as to whether or not the case warrants filing a charge of discrimination, and then later whether or not it really warrants actually filing suit. The other 2, options 2 and 3, are virtually identical. I get a letter back either from the company or from its attorney, and both letters say the exact same thing except for the ending. Both letters tell me I'm wrong, I don't really understand the facts. My client hasn't been honest with me. Here's some information I probably don't know and I should know. And therefore, this is a bunch of malarkey. Then letter number 2 says, and go to HE double hockey sticks. Now, that's essentially the same as the no response letter, except they've now given me lots of factual information.
Right, and you can put that letter in your file.
Right.
Yeah.
But I have information I can now use. The third version is the exact same letter. And they even tell me to go to HE double hockey sticks, a phrase from my youth. But then there's another sentence. However, in an effort to avoid protracted, unnecessary, expensive litigation, we offer. And now they make a monetary offer, and it's usually very small. Mm-hmm. And what I tell my clients is, never worry about that first offer. Be happy there's an offer, because now we are talking. Now the other attorney and I are going to have a dialogue where I'm going to come down, he's going to go up, or I'm going to come down. And we're going to keep arguing with each other and trying to move closer together, or maybe even do a mediation, to try to settle your situation before you ever even have to file that charge. And sometimes you not filing that charge has value to that company because they just don't want the negative publicity. Mm-hmm. And by the way, when I file a charge, depending upon the case, I often put an ad in the newspaper, big half-page ad, approved by the Florida Bar. Every ad has to be approved by the Florida Bar. And the ad essentially says, have you been sexually harassed? Or do you know of anyone who has been sexually harassed by company X? Now, I do that for 3 reasons. 1, I may get witnesses that help me in that case. Mm-hmm. 2, I may get new clients. And 3, I want to terrorize that company. I want that company to know that that's coming if we don't settle. And so very often now in my demand letters, I include a copy or 2 of some of my prior newspaper ads. Right. To say, don't just think.
You have one that says your name here?
Yeah. That'd be that's a good idea. I like that. I'm going to use that. I'm going to modify my template. And I send a couple of them just so they realize, don't assume this is just a lawyer bluffing, or I'm going to say this word, FCC, but please don't come after me. It's what a client said to me once. They actually gave me a pen that had it on it because they loved it. We had a great settlement. And they said, lawyer bullshitology. And I don't want the other side to think that this is just a bunch of lawyer bullshitology. I want them to think that I'm serious. Can't say that.
No.
Okay.
Yeah,
I'll pay the fines.
Let's don't do that again.
All right. We won't. Did you bleep me out?
Yeah.
Okay. Well, goodness. I thought George Carlin resolved all those issues and you're allowed to say everything.
There's still like 7 words that are
No, that's
no
7
good.
words case. I know that 7 words case. All right. I won't do that
I'm
anymore.
feeling faint over here.
So, we do the demand letter, and hopefully the pressure of some public disclosure has some value. Not always. And if that works, wonderful. If it doesn't work, then we move forward with a charge of discrimination. But, that's what we do typically beforehand. Now, since we are running out of time, we won't go to a whole new topic, but let's just talk a little bit about what comes next. The charge of discrimination doesn't get you a settlement. You file the lawsuit. You proving to the defendant employer that you're really serious because now you filed the lawsuit. That doesn't get you a quick, okay, well, let's talk. What happens now? In federal court, generally around 18 months of discovery. Discovery, I'm asking the employer for documents. I'm sending them written questions they have to answer under oath. I'm sending them what are called requests for admissions, admit this, admit that. And the consequence of a denial when they should have admitted is they have to pay my fees. A lot of what is going on right now in the national news. And they're doing it to me too. They want to know, what do I know? Mm-hmm. Who are my witnesses? Who have I got statements from? So we go through depositions under oath. We go through roughly 18 months, 12 to 18 months of that. And then we do what are called motions for summary judgment, where we say to the judge, some of the facts aren't in material dispute. You can decide this is a matter of law. sometimes plaintiffs lose on summary judgment or lose partially on summary judgment. Rarely do plaintiffs win on summary judgment in federal court on discrimination cases. So the goal then is to get past that, and now you go to trial.
So, in all of this time, the employee is still going to work.
Well, in the best of circumstances, yes.
Mm-hmm.
In the worst of circumstances, they've been terminated, and we have a retaliation claim. And so retaliation we can talk about next week quickly. We're going to take one last call before the show is over. Harry is on line 1. Hello, Harry. How can I help you?
Hi, Stuart. How are you?
I'm doing good.
My wife was operated on back in October by a vascular surgeon. And at the time, he said that he was like one of the best that there was. And when the operation was over, I was in the waiting room, and he came out and said everything went fine, and she'll be in recovery for a couple of hours. And he said we had to do very little. It was in her leg. They removed some veins. Make a long story short, she wound up with actually 10 wounds and 10 areas to heal on her leg.
Okay.
And they make an incision for the main vein right in the private part area.
Right.
At a crease there. And he said that would be the longest one to heal. Well, here it is all these months later, and it still isn't healed. She's been back to him 2 times, and he said, well, there's not much you can do. Just put some antibiotic cream on it, and it'll go away eventually. Well, now it's getting infected. And when we did go back one time, instead of speaking to his doctor, we spoke to his assistant, who's a CNA.
Right.
And she said that she did most of the surgery. So, I mean, this guy's almost like a quack at this point in time.
All right, let me give you, because we're sort of running short on time, let me try to give you some quick advice. First, I would say that, unfortunately, not every surgery that goes wrong is negligence. But a lot of them are. The first thing I would do is take your wife to another vascular surgeon.
Or wound care, maybe.
Yeah, or for a second opinion.
Yeah. Right.
And if you can, I would get the medical records from the doctor and the hospital and see if you can have somebody review them and tell you whether they think the standard of care fell below what is expected. The next thing I would do is I would contact a number of lawyers that do medical malpractice because they're the ones that have all these contacts, all these doctors and all these nurses that they review medical records to see if they can find evidence of negligence. If they do, you may end up having representation. Or you may find out that for whatever reasons, this was a bad result, but it wasn't really negligence.
Right.
So, I can't say obviously, but I would try to take her to another doctor to get an opinion, and then I would certainly be calling some medical malpractice attorneys, to discuss the situation with them and see what they say.
Could she call your office and get some
Absolutely.
advice on what attorneys she could call?
Absolutely. I can give you the names of a few medical malpractice attorneys. Have her call my office, and we'll be happy to do that.
I thank you very much, and you have a great show, by the way.
Thank you very much. I appreciate it.
Thank you.
Bye-bye.
Bye-bye.
Well, we're just about out of time. We have, a minute I'm being told, so I can't talk much. Next week, we'll talk about how the other forms of discrimination are very similar and in terms of the process, and we'll go into hopefully some new areas.
I mean, there are people out there who may go, aha, I've been discriminated against, that don't even realize that,
Sometimes
this
that
may
happens.
have happened.
And it's unfortunate. Sometimes discrimination can be very subtle and hard to prove. There are ways. So if you think that you're being discriminated against, you should talk to a lawyer, really. And with that, I will say good day, good weekend. Hope you have a wonderful time. I'm Stuart Address. This is Ask a Lawyer, and my office number is 772-781-8003. Have a wonderful weekend. Take care.
This is WPSL Port St. Lucie, the talk of the Treasure Coast.